Hello everyone. The topic today we will cover is relation of partners. Relation of partners to the third parties. It is coming under Unit 4 of our subject Special Contracts, and the name of the act is the Indian Partnership Act of 1932. So let us discuss about relations or relation of partners to the third parties. What are their authorities? So this has been divided in Indian Partnership Act of 1932 into two categories. The first one is expressed authority and the second one is implied authority. So expressed authority, it means that in the agreement or in the partnership deed, it has been expressly written, or we can say it has been expressed explicitly what are the authorities of the partners in the partnership firm. So when through words, either spoken or written, or we can say orally, etc., we have identified that what is the authority of the partners, or what are the authorities of the partners between them. Okay, between them, these things are coming under expressed authority. But there are certain things which cannot be said or expressed, but it is getting covered in an implied way. Okay, so this is the implied authority. Let us make it more clear here. Now, when we talk about implied authority, it is coming under section 19 to section 22 of the Indian Partnership Act of 1932. Okay, section 19 to section 22 of this act. And expressed authority it has been covered in section 18 of the Indian Partnership Act 1932. So section 19 subsection 1, it is talking about, or it talks about that there are certain implied authorities which are not needed to be expressed. Okay, which are not needed to be expressed to the partners of the partnership firm, but they are having those authorities. The partners are having those authorities. Okay, those implied authorities. Now, what might be the authority in this regard of the partners? Like, for example, if you want to do anything for the, let's say, for the benefit of the partnership firm, or we can say in favor of the partnership firm, you can do it. Secondly, you can at the same time, being a partner of the partnership firm, use the name of the firm if you are acting for the benefit of the firm. If you are acting for the benefit of the firm, or if you are working or taking action in favor of the partnership firm, okay, you can use the name of the firm. Okay, so the action which is related to the subject matter of the partnership firm, and this action must be related to the subject matter of the partnership firm. So you can use the name of the partnership firm if you are acting for the benefit of the partnership firm, or if you are working in favor of the partnership firm. So the action which is related to the subject matter of the partnership firm. Subject matter, which means by which we do business, for which the, or we can say for which the partnership firm got started. So this is the subject matter. So actions related to that subject matter can be taken into consideration. Okay, it can be taken. So actions related to that particular subject matter of the partnership firm, that can be taken. Okay, but it should be in favor of the partnership firm. It should be done, that action should be taken for the benefit of the partnership firm. Okay, for the benefit of the partnership firm. Here action can be taken in the implied authority. Okay, here action can be taken in the implied authority without informing other partners of the partnership firm. Like, for example, let's say in the emergency, in the emergency related issues of the partnership firm. Okay. So there are so many aspects of implied authorities which have been explained in section 19 subsection 1. Like for example, let me cite one example. Like if you have received any payment after selling the goods, you can give what? You can give receipt of it in the name of the partnership firm. If you have received any payment after selling the goods, you can give receipt of it in the name of the partnership firm if the sale has been done in the name of the partnership firm related to its subject matter. So in this way, there are examples which includes implied authorities, which are not necessary to be expressed. Like if a partner is absent, let's say if you want to take action on behalf of that partner, and suppose you are also one of the partners, it can be taken. You can take such type of actions. Such type of actions you can take. So there is no need of expressing all this in words, written or spoken, or maybe orally expressed. But these are impliedly applicable. If a partner, only if a partner is working with a third party representing the firm, or we can say acting on behalf of the firm for the benefit of the firm, these things will be impliedly applicable in such situation or situations. So when a partner is working as an agent with the third party, okay, when a partner is working as an agent with the third party, that is representing the partnership firm to the third party, section 19 subsection 1, these implied authorities of the partners have been given. But there are certain restrictions also when it comes to restrictions related to the implied authorities of the partners, or we can say limitations of implied authority, which are coming under section 19 subsection 2, like whatever decisions related to the let's say immovable property, immovable property, a partner cannot take the decision without the consent of all the other partners. How? Let me cite one example. Like for example, if a partner wants to buy an immovable property in the name of the partnership firm, let's say, for the benefit of the partnership firm, the consent of all the partners, here it is very important. The consent of all the partners, it is needed here. So if there is a dispute related to an immovable property, related to the partnership firm, the consent of all the partners, it is needed. Okay, so a partner cannot go and deal, or we can say communicate with third parties related to the immovable properties without taking consent of all the other partners. Likewise, a partner without taking consent of the other partners cannot just go to a bank and open one bank account there. So these things have been restricted when it comes to section 19 subsection 2, okay, when it comes to implied authority and its limitations. Okay, but if, let's say, in the partnership deed, or let's say while making the partnership deed, it was expressly mentioned that a partner without taking consent of other partners may open a bank account, let's say, in the name of the partnership firm for the benefit of the partnership firm or in favor of the partnership firm, this thing can be taken into consideration as an exception of section 19 subsection 2. Why? Because what happened here? It was expressly mentioned where? In the partnership deed. Okay, in the partnership deed, it was expressly mentioned there that a partner without taking consent of other partners may open a bank account in the name of the partnership firm, but that must be for the benefit of the partnership firm. or that must be in favor of the partnership firm. Okay. So now let's talk about expressed authority. Now, as we know, expressed authorities must be expressed either through words, written, spoken, orally, etc. Okay. That is, things must be expressed and explicitly be communicated with the other partners. Okay. Now, if you discuss about extensions of partners, implied authority, when, how the implied authorities can be extended. Yes, like during emergency or urgency, let's say. And it has been discussed in Section 21. Section 21 of the Indian Partnership Act 1932. Authority to act in an emergency. So during emergency, the implied authority can be extended. The implied authority of a partner or of the partners can be extended. Okay. And where the action, if it is beneficial, or we can say in favor of the firm, beneficial in nature, beneficial for the partnership firm, or in favor of the firm, then there the implied authority can also be extended. Okay. So now let us come to effect of admission. Effect of admission by a partner, which is coming under Section 23. Section 23 of the Indian Partnership Act of 1932. So, if a partner admits something, or let's say claim to be a partner of the partnership firm and communicates with a third party, okay. Now, whether this admission or communication made by the partner will be regarded as relevant or not. It will be treated as relevant if the partner is in reality or in actuality is a partner in the partnership firm. Only if the partner is in reality, or we can say in actuality, is a partner in the partnership firm, then it can be treated as relevant. Okay, it can be treated as relevant. Now, let me cite one example here. Let's say A communicated with Y. A communicated with Y, let's say, regarding a transaction. A transaction which is related to the partnership firm. Now, let's say Y is the third party here. Now, this admission or communication done by A will be regarded relevant only if A is the real partner. Only if A is the real partner, this admission or communication done by A to whom? To Y the third party. To Y the third party will be regarded relevant. Let's say, let me give another example here to make this section 23 more clear. Let's say A joined the partnership firm on, let's say, 5th March 2020. A joined the partnership firm on 5th March 2020. But A made the communication with Y regarding a particular transaction related to the partnership firm, let's say on 5th February 2020. So on 5th February 2020, A made the communication with Y regarding a transaction which was related to the partnership firm. So here, when A made the admission, or we can say communication with Y, who is the third party, A was not a partner at that time. So here, this admission or communication made by A before joining the firm will not be regarded relevant. Okay, it will not be regarded relevant. Now let us come to Section 24. Section 24, it is talking about effect of notice to acting partner. Effect of notice to acting partner. So if a partner, let's say, has been given notice it can be considered that all the partners also receive the notice. Okay. So the vital question is, if a partner has been given notice, whether it can be considered that all the other partners also receive that particular notice. This is the question. And what will be the answer of it? What will be the answer? The answer is yes. As the partners are working as what? As agents of each other. But if a partner has been specifically charged for, let's say, for a fraud case, and that partner has received the notice of what? Of fraud allegation or charge, then it will be considered that all the partners have not received the notice. It is only specifically for that partner only who has been charged for a fraud case. Okay. Now, let's little bit discuss about liabilities to the third parties. Liabilities to the third parties. And then we will go to section-wise explanation. Okay. Now, liabilities to the third parties. That is, what are the liabilities the partners are having towards the third parties? So, it has been explained in Section 25 to Section 27 of the Indian Partnership Act 1932. It has been explained here that if there is a contract, okay, if there is a contract, what are the liabilities? Obviously, every partner will be liable. Okay. So, if there is a tort, then it will be considered when it has happened. Okay. If there is a tort, then it will be considered when it has happened, whether during the course of the business of the firm it happened or not. Then all the partners will be liable for the partner who caused this tortious act against a third party. I am repeating this again. Okay. So if there is a tort, let's say, then it will be considered when it has happened, whether during the course of the business of the firm it happened or not. Then what will happen? If it is so, then all the partners, that is, if that particular tortious act was done against the third party during the course of the business of the partnership firm, then all the partners will be liable for what? For the partner who caused this tortious act against the third party. Now, tort, as we know, in civil law, it is an act that brings harm to someone. Now, here in this case, harm, it has been caused to the third party. Harm has been caused to the third party. When the rights of the third party is infringed by one of the partners of the partnership firm during the course of the business of the partnership firm, then all the partners will be liable in this regard. Okay. And if there is a fraud, tort, breach of contract done against a third party by one of the partners during the course of the business of the partnership firm, of course, then all the partners here will be liable. Like, for example, if a let's say partner caused harm or let's say infringed the rights of a third party through misrepresentation. Like, if a partnership firm is responsible for Y type of business, the subject matter of the firm is Y type of business, but suppose A, being one of the partners, A is one of the partners here, let's say, created impression in the mind of a third party that the firm is responsible for X type of business. Now, what is the subject matter of the partnership firm? The actual subject matter is Y type of business. But A, who is also one of the partners, created impression in the mind of the third party that the firm is responsible for X type of business. So this is a case of misrepresentation. So here A misrepresented the subject matter of the partnership firm to the third party. So here all will be liable for the conduct of A. All the partners will be liable for the conduct of A, because A is also one of the partners of the partnership firm. So these cases are related to the relations of partners to the third parties, where the expressed and implied authorities have been discussed. Now the next section is section 30. Section 30 we will not discuss, because I have prepared one separate lecture for this topic. That is section 30. It is talking, as you know, it is talking about minor as a partner. Section 30, minors admitted to the benefits of partnership firm, we have already discussed. Now let us discuss this topic section wise. Okay, section wise. Now, relations of partners to the third parties. Okay. Now, chapter 4, that is sections 18 to 30 of the Indian Partnership Act of 1932, it contains provisions concerning the relations of partners to the third parties. We have already discussed. The relation between partners on one hand and third parties on the other is founded on the principle of mutual agency. Mutual agency as contained in section 18 of the Act. Okay? Which is talking about subject, I am reading it from the Bare Act, subject to provisions of this Act, a partner is the agent of the firm for the purpose of the business of the firm. So this is coming under section 18. Thus we can say every partner is embracing the character both of what? Both of principal and that of agent. However, the partners are the agents of the firm only for the business purposes. Only for the business purposes related to that partnership firm. That is, they are not agents, we can say, outside those purposes. This agency operates against all the partners. That is active as well as we can say dormant or sleeping partners. Okay, we have discussed about the types of partners. Okay, so this agency, it operates against all the partners, all types of partners, active, whether be it active, dormant or sleeping, anything. Okay, so it operates against all the partners. Now section 25 of the Indian Partnership Act 1932 also made liable every partner with all his co-partners, and also severally for all the acts of the firm done while he is a partner. Now section 25, I am repeating this again, section 25 of this act also made liable every partner with all his co-partners, and also severally. Severally means when applied to a number of persons, the expression severally liable usually implies what? That each person is liable alone. Severally liable usually implies that each person is liable alone. Okay. So section 25 of the Act also made liable every partner with all his co-partners, and also severally for all the acts of the firm done while he is a partner. Okay. Now section 25, as it is talking about liability of a partner for acts of the firm. Liability of a partner for acts of the firm. So every partner is liable jointly with all the other partners, and also severally for all the acts of the firm done while he is a partner. Now the rule laid down in this particular section, it flows from the rule which has been laid down in section 18 of this act. The liability of a partner for the acts of the firm is both joint as well as it is several. Thus a creditor can sue. Who is the creditor? Who is the creditor? Creditor here is a third party. Okay. Thus a creditor can sue the partners jointly as well as separately and successively. Okay, so the liability of partners for acts of firm arises only while they are partners. I am repeating this again. This is very important. The liability of partners for acts of firm, it arises only when? While they are partners. An act done or an action taken after a partner ceases to be so, either by death or maybe retirement or maybe dissolution, etc., it will not bind him except where the liability is continued by reason of the principle of holding out that we will discuss in section 28. Okay, now let us come to section 19. Okay, so section 19, it is talking about implied authority of the partner as agent of the firm. Implied authority of the partner as agent of the firm. So we will discuss about section 19. Implied authority of the partner as agent of the firm. So let me read it from the bare act for a while. Okay. So the subsection 1 of section 19, it is talking about, subject to the provisions of section 22, the act of a partner which is done to carry on in the usual way business of the kind carried on by the firm binds the firm. Okay, so the authority of a partner to bind the firm conferred by this section, that is by section 19, is called his implied authority. So in order to be within the implied authority of a partner, the act must be done, number one, the act must be done in the conduct of business of the kind carried on by the firm. Okay, in the usual way of such business. And number 3, it is also necessary, as provided in section 22 that we will discuss, that the act must be done in the name of firm or in any other manner expressing or implying an intention to bind the firm. Okay, to bind the firm. So let me just simplify it. Section 19. We are talking here about section 19, which is talking about implied authority of the partner as agent of the firm. Suppose, I am just citing one example here. Suppose is one of the partners. Let's say the name of the partnership firm is Y firm. Okay, let's say the name of the partnership firm is Y firm. So A, without informing the other members or other partners of the partnership firm, let's say did one transaction which was related to the partnership firm, and at the same time A also used the name of the partnership firm while doing the transaction with a third party. What was the name of the partnership firm? Y firm. Okay, let's say T is the third party here. This is just an example. Let's say T is the third party here. Here, though A did the transaction related to the partnership firm with T, who is the third party, so it has been done during the conduct of the business of the firm. We were talking about the during the conduct of the business of the firm. Okay, that the action or the act, it must be related with the conduct of the business of the firm. Okay, so here, though A did the transaction related to the partnership firm with T, okay, so it has been what? It has been done, we can say, during the conduct of the business of the firm. Okay, at the same time, it will be known as the usual way of firm's business. At the same time, it will be known as the usual way, quote unquote, of firm's business, because the transaction was done maintaining what? Maintaining the purpose and the subject matter of the partnership firm. Suppose, let's say the partnership firm deals with Y type of business. Okay, and the transaction was done accordingly, maintaining Y type of business. Here the act of the partner A, it will bind the entire firm, or we can say will bind the other partners also. And here the binding will be impliedly applicable, as no expressed communication is needed here. Okay. Now let's say the transaction was done with a bona fide intention. Let's say for the benefit of the partnership firm or in favor of the partnership firm. It will be treated as a lawful or legal binding upon the entire partnership firm then. Okay. So this is an example which is coming under section 19 subsection 1. Okay, section 19 subsection 1. Now let us discuss it more. Lindley on the law of partnership said whether a given act was done by a partner in carrying on the business in the usual way is a question to be determined by the nature of the business and by the practices of persons engaged in it. So there are two case laws we will study here. The first one is a 1928 case. The name of the case is Mathura Nath versus Bageshwari Rani. Mathura Nath versus Bageshwari Rani. So in this case, the business of the firm was of catching white elephants. And the firm used to enter into agreements for hiring elephants for the purpose. A partner entered into a similar agreement for hiring an elephant. Entered into a similar agreement for hiring an elephant. This act of the partner was held to be done of the kind of the business carried on by the firm. This act of the partner was held to be done of the kind of the business carried on by the firm. Another example, another case law we will cite here is Sanganer Dal and Flour Mills versus FCI, Food Corporation of India, 1992 decision, AIR 1992 SC 481. So in this case, a contract was entered into by one of the partners of the partnership firm with the Food Corporation of India for the supply of dal, pulses. This contract was held to be binding on the other partners of the firm when the validity of the contract was not denied by the other partners. This contract was held to be binding on the other partners of the firm. Why? Because the validity of the contract, it was not denied by the other partners of the partnership firm. Okay. So these are some of the case laws we have discussed. The first one is Mathura Nath versus Bageshwari Rani, and the second one Sanganer Dal and Flour Mills versus FCI. Now let us come to section 19 subsection 2. Section 19 subsection 2. So it is talking about limitation of implied authority. Limitation of implied authority, section 19 subsection 2. So a partner may be prohibited. From doing an act which would otherwise be within the scope of his implied authority. That is, implied authority, in simple words we can say, may be restricted here. Now this restriction may be of two types. Two types of restrictions are there when it comes to limitation of implied authority. The first one is statutory restriction or statutory restrictions. Second one is restriction imposed by partnership deed. I am repeating this again. The first restriction is, number one, statutory restrictions. The second one, restriction imposed by partnership did. Now, let me cite one example here. Okay. Now, section 19, subsection 2, one example can be cited here. Let's say if the partner A is one of the partners, if the partner A of a partnership firm does this act means we are continuing the previous example here. Okay, we are continuing the previous example here. We are talking about section 19, subsection 2. If the partner A does this act with a mala fide intention, let's say A opened a bank account. Okay, let's say A opened a particular bank account in the name of the partnership firm, let's say for personal financial gain, and created impression in the mind of the third party to put money in that particular bank account. Here, it is a case of fraud because A did here what? Misrepresentation without informing other partners of the partnership firm, and as such, A will be prevented to do such act as per section 19, subsection 2. So we can say there can be, as we have discussed, there can be two types of restrictions when it comes to limitation of the implied authority of the partner. The first one is statutory restrictions. The second one is restrictions imposed by partnership deed. Now, let us discuss a little bit about the statutory restrictions. Suppose, let's say, A did transaction with the third party, and the intention was also bona fide in nature to save the firm, let's say, from financial crisis. Let's say the third party here is T. T here is having some sort of criminal allegation, and a particular act, particular legislation, or we can say law of the land, is explicitly preventing such type of transactions with a criminally alleged person. So here the statutory restriction is not to do transaction with such persons having criminal allegations. So here there will not be any implied binding of all the partners for the act done by A. Here there will not be any implied binding of all the partners for the act done by A. So this is the example of statutory restriction. So the second example, let us discuss about restrictions imposed by partnership deed. Now we are talking about two types of restrictions when it comes to limitation of the implied authority of the partner. The first one we have already discussed, statutory restrictions, and the second one is restrictions imposed by partnership deed. Restrictions imposed by partnership deed. Second example, let's say when a partnership firm was formed, it has been explicitly mentioned in the partnership deed that when it comes to purchasing immovable property, the consent of all the partners it should be taken. Suppose, let's say A purchased one immovable property and the third party here is T. So A purchased the property from T. A being one of the partners violated one of the substantial conditions of the partnership deed by not taking consent of all the other partners. So here the implied binding upon all the partners for the act done by A by purchasing the immovable property, that particular land, will not be there. A here will be personally liable to the third party T. Okay, to the third party T. Now, when it comes to section 19, subsection 2, in the absence of any usage or custom of trade to the contrary, the implied authority of a partner does not empower him to, there are certain points. A. Submit a dispute relating to the business of the firm to arbitration. B. Opening a banking account on behalf of the firm in his own name. C. Compromise or relinquish any claim or portion of a claim by the firm. D. Withdraw a suit or proceeding filed on behalf of the firm. E. Admit any liability in a suit for proceeding against the firm. F. Acquire immovable property on behalf of the firm. G. Transfer immovable property belonging to the firm. Or H. Enter into partnership on behalf of the firm. So these restrictions are effective against all the world, whether a particular person contracting with the firm has knowledge of them or not. Okay, so this is very important. A limit on implied authority of the partner could also be imposed through an agreement between partners as permitted by section 20, which we will discuss. Okay, so we have already cited two examples here when it comes to statutory restrictions and restriction imposed by partnership deed. Now let us come to section 20, which is talking about extension and restriction of partners' implied authority. Section 20, extension and restriction of partners' authority. So the partners in a firm may by contract between the partners extend or restrict the implied authority of any partner. Notwithstanding, in spite of any such restriction, any act done by a partner on behalf of the partnership firm which falls within his implied authority binds the firm, unless the person with whom he is dealing or knows of the restriction or does not know or believe that partner to be a partner. Okay, I will simplify it. Thus, if the act in question is within the scope of the partner's implied authority, the firm is bound unless it can be shown A. that the person contracting with the partner had knowledge of the restriction, or B. that he did not know or believe the partner to be a partner. Now, let me simplify it by an example here. So, we are talking about section 20, extension and restriction of partners' implied authority. So, there can be extension and also restrictions, okay, which can be imposed when it comes to the implied authorities of the partners. And such extensions and restrictions can be imposed only through contract, only through agreement between the partners themselves. Okay, between the partners themselves. They will create such type of agreement. They will create such type of contract. Okay. So, whatever will be done by a partner, whatever action will be taken by a partner falling within his or her implied authority, such action by a partner will bind the entire firm. Okay, it will bind the entire firm. And partnership firm also can impose restrictions upon such implied authority through contract, or we can say mutual contract among the partners. But here, but there are certain exceptions also when such a act of a partner will not bind the partnership firm in an implied way. Let's say while doing a contract, the third party had the knowledge of such restrictions, let's say, or the third party did not know or believe the partner to be a partner. So here the act done by the partner will not bind the entire firm, because the third party had the knowledge of the restrictions of the partnership firm, and at the same time also did not believe the partner to be an actual partner. But suppose the restriction placed on implied authority is not known to the third party, let's say. So the partnership firm then would be liable to such third party, okay, to such third party. Now let me explain it. Section 20. So section 20, let us discuss two case laws here, okay. The first one is Credit Company Limited versus Garod. Credit Company Limited versus Garod. It's a 1962 decision. So two partners, one acting and other sleeping, in a business of letting lock of garages and repairing cars. So a clause in the partnership deed prohibited the partners from buying and selling cars on behalf of the firm. So the acting partner sold a car and obtained some money for which he was not entitled. The sold car was not of the firm, was not of the partnership firm. On disclosing such fact, buyer claimed his money from the sleeping partner. So he was held liable, as garage usually sell second-hand cars. So the act was within the scope of the implied authority, and plaintiff did not know of any restriction in the deed. He did not know that he was dealing with a partner within the scope of his usual authority. Okay, so this is the first case, Credit Company Limited versus Garod, 1962 case. Now the second case we will discuss here is Motilal versus Unnad Commercial Bank. Motilal versus Unnad Commercial Bank, 1930 decision. So here what happened? A restriction was placed on the partners. A restriction was placed on the partners to borrow money by an agreement. One of the partners borrowed money without any third party knowing about such restrictions. So what happened here? A restriction was placed on the partners to borrow money by an agreement. One of the partners borrowed money without any third party knowing about such restriction. The firm was held to be liable since third party did not know about the restriction. Okay, third party did not know about the restriction. So we have to understand, this is very important. We have to understand this. There is a difference between statutory restriction that we have discussed in section 19 subsection 2. So there is a difference between statutory restriction imposed on implied authority by section 19 subsection 2 and restriction imposed under section 20 by contract among the partners. The statutory restrictions are effective against all the third parties as they are deemed to be having the knowledge of restrictions. I am repeating this again. The statutory restrictions which are coming under section 19 subsection 2 are effective against all the third parties as they are deemed to be having the knowledge of restrictions. Okay. And third parties, however, cannot be presumed to be having the knowledge of the restriction which the partners may impose by a contract between themselves. And therefore, a third party can be bound by a restriction imposed under section 20 if he had the actual knowledge of such restriction. If he had actual knowledge of such restriction. Okay. Thus, we can say if restriction placed on implied authority is not known to the third party, the firm would be liable to such third party. The firm would be liable to such third party. Okay. So this was section 20. Now let us come to section 21. Section 21 of the Indian Partnership Act 1932. Now section 21 is talking about partners' authority in an emergency. Partners' authority in an emergency. Let me read it. Section 21 of the Partnership Act provides that a partner has authority. A partner has authority in an emergency to do all such acts for the purpose of protecting the firm from loss as would be done by a person of ordinary prudence, of ordinary intelligence, in his own case, acting under similar circumstances, and such acts bind the firm. So we can say this section confers an authority on a partner. This section confers an authority on a partner for doing all such acts for purpose of protecting the firm from loss as would be done by a person of ordinary prudence. So what are the requirements of this particular section? These are: number one, there should be an emergency. If we simplify this particular section, that is section 21, there should be an emergency. This is the first one. The second point is the partner should have tried to protect the firm from loss threatened by emergency. The partner should have tried to protect the firm. The partner should have tried to protect the firm from loss threatened by emergency. And number three, the act must be reasonable in circumstances. The act must be reasonable in circumstances. Now let me give one example of section 21 to make it more simple. So we are talking here about partner's authority in an emergency, section 21. Now let me cite an example here. Suppose, let's say suddenly there was a financial emergency in a partnership firm. Let's say there was a sudden financial emergency in a partnership firm. A being the only partner who was in the station. A is one of the partners and he was the only partner who was in the station. He became bound to take quick and immediate action. A became bound to take quick and immediate action because other partners were out of the station. So it was not possible for A to communicate, let's say, with other partners of the firm due to various reasons, various circumstances, let's say. Now A here is having the authority to take emergency action. Why? To save the partnership firm from getting bankrupt. Okay. So the act here is not only done to protect the firm as a whole, but it was also, we can say, reasonable in nature, and it was also done with a bona fide intention, not with a mala fide intention. Okay. So this is what section 21 had to say. Now let us come to section 26. Section 26, liability for torts and wrongful acts. Liability for torts and wrongful acts. Let me read this section first of all. Section 26, liability of the firm for wrongful acts of a partner. So we are talking about liability for torts and wrongful acts. So where by the wrongful act or omission, act or wrongful omission of a partner acting in the ordinary course of the business of a firm or with the authority of his partners, loss or injury is caused to any third party. Loss or injury is caused to any third party or any penalty is incurred. The firm is liable, therefore, to the same extent as the partner. So if you simplify it, this is a this particular section, section 26, it is based upon the principle of vicarious liability. Okay, so a principal is vicariously liable for the torts and other wrongful acts committed by his or her agent, and they should be done in the course of the business of agency. Every partner being an agent of the firm, of the partnership firm, the same principle has been recognized by Indian Partnership Act. Okay, now let me simplify this section 26. Let me just cite one easy example here. Let's say, suppose A is one of the partners. A is one of the partners. Let's say A was supposed to do a contract with T. Now T here is the third party. So here, let's say A with a mala fide intention for personal financial gain took some extra money from T. Now, as we have discussed, T is the third party, saying what? That let's say A with a mala fide intention for personal financial gain took some extra money from T, saying it as a part of the, let's say, contractual transaction. Okay, which was actually not part of the same. So other partners were not aware of this unlawful financial gain done by A. When T, that is the third party, faced financial loss and sued against the partnership firm, other partners cannot say they are not responsible for this. Other partners cannot say at that time that they are not responsible for this. All the partners here will be liable for the act of the partner A, because the principal and agent, because of the principle of principal and agent, or you can say because of the principle of vicarious liability. Vicarious liability will be applicable here. Okay, let me repeat it again. Okay, section 26, liability for torts and wrongful acts. Suppose A is one of the partners. Okay, A was supposed to do a contract, let's say, with T. T is the third party. So here, let's say A with a mala fide intention for some sort of personal financial gain took some extra money from T, saying it that it is a part of the contractual transaction, which was actually not part of the same. Okay, so other partners were also not aware of this unlawful financial gain which was done by A, who is also one of the partners. When T, the third party, faced some financial loss and sued against the firm, other partners at that time cannot say that they are not responsible for the act which was done by A. All the partners will be liable for the act of the partner A because of the principle of principal and agent, or you can say vicarious liability will be applicable here in this regard, in this particular example. Now let's come to section 27. Section 27, it is talking about liability for misappropriation. Liability for misappropriation. Okay, let me just cite some two case laws. As far as section 26 is concerned, let us discuss about Llyod versus Grace Smith. Llyod, Llyod versus Grace Smith. It's a 1912 decision. So in this particular judgment, it was laid down that it is now settled that a principal is liable for the fraud or any other intentional wrong of his agent acting within the scope of his authority, whether the fraud is committed for the benefit of the principal or for the benefits of the agent, or whether the principal in fact derives any benefit or not. Then in another case, it was held, the name of that case is Hurruck, Hurruck, Hurruck versus Gobind Lal, 1906 case. So one of the partners, in this case, one of the partners received the stolen goods and credited the sale proceeds to the credit of the firm. It was held that both were liable for conversion to the owner of the goods. So I am repeating this again. In this case, one of the partners received the stolen goods and credited the sale goods to the credit of the firm. It was held that both were liable for conversion to the owner of the goods. Okay. And there is another judgment, 1903 judgment, Hamlyan versus John Hoston. So in this case, where acting partner, without knowledge of his sleeping partner, induce a clerk of the plaintiff by bribery to give confidential information. It was held that although the wrong of inducing breach of contract had been committed by only one of the partners and other partner had no notice of the same, yet since wrong was done in the scope of the authority of the wrongdoing partner, I am repeating this again, yet since wrong was done in the scope of the authority of the wrongdoing partner, the other partner was also held liable. Okay, so vicarious liability. So this is what section 26 it is all about. Now let us come to section 27. So section 27 is talking about liability for misappropriation. Section 27. Liability of firm for misapplication by partners, where 1. A partner acting within his apparent authority receives money or property from a third party and misapplies it, or 2. A firm in the course of its business receives money or property from a third party and the same is misapplied by any of the partners, the firm is liable to make good the loss. So as far as section 27 is concerned, in this section, two kinds of cases of misapplication of money or property have been mentioned. So section 27 is talking about liability for misappropriation. So as we have discussed in this section, two kinds of cases of misapplication of money or property have been mentioned. Money or property may be received by a partner and then he misapplies it without accounting for it to the partnership firm. Or it may be received by the partnership firm and same is misapplied by any of the partners. Now in both the cases, the firm is liable to make good the loss to the third party here. Okay. Now, as we are discussing about section 27 of the Indian Partnership Act 1932, let us simplify it. So section 27, it is talking about liability of firm for misapplication of partners. So 2 points we have to remember here. Number 1, money or property received by a partner. Number 2, money or property received by the firm and same misapplied by any one of the partners. Now let us discuss about, let me give one example which is related with the first point. Okay, the first point is money or property received by a partner. The first example which I will cite here is that, let's say A was appointed by the partnership firm to do, let's say, to do a financial transaction or a contract with T. T here is the third party. Suppose T, the third party, T was supposed to pay, let's say, 1 lakh rupees to the partnership firm. as a part of the financial transaction. But let's say A demanded extra 50,000 rupees from T, the third party. So here A, for personal financial gain, caused financial damage to T, the third party. Here A received the money on behalf of the partnership firm and did what? He did what he was not supposed to do with the third party. Here entire firm will be liable for the act done by A. And T should be, that is the third party, should be compensated by the partnership firm. Now, let me give one example which we can relate with the second point here. Then the second point is money or property received by the firm and same has been misapplied by any one of the partners. Okay. So the second example here. Let's say the second example. Let's say money amount of 1 lakh. 1 lakh amount has been received by the partnership firm. And one of the partners, let's say the name of the partner is A. A took 20,000 out of the money received by the partnership firm. That is 1 lakh. Out of 1 lakh, A took 20,000. Suppose other partners are not aware of this unlawful activity done by A. And suppose the firm afterwards accuse the third party for paying inadequate amount of money. So here the third party is not responsible. And for harassing the third party, the entire firm will be responsible to compensate the third party. So the act done by A here will invoke the principle of vicarious liability. Okay? Of vicarious liability. So as far as section 27 is concerned, there are two case laws, important case laws we will discuss. The first one is Rhodes versus Moles, 1895 case. So in this case, the plaintiff applied to R, a member of solicitors, requesting him to raise a loan on the mortgage of his freehold estate. R obtained loan, but told to plaintiff that lender required some additional security. Plaintiff accordingly handed to R some share warrants payable to bearer to be used as security. Now, what is a share warrant? A share warrant is a document. Okay, it is a document issued by the company under its common seal, stating that its bearer is entitled to the shares or stock specified therein. So we can say share warrants are negotiable instruments. So here what happened? Plaintiff accordingly handed to R some share warrants payable to bearer to be used as security. R misappropriated the share accounts and absconded, or we can say flew away. His partners had no knowledge of this, but it was held that the transaction was a partnership transaction, and R's partners were also held liable for the value of shares misappropriated. And second case here, the name of the case is Blair versus Bromley, 1847. So in this case, in a firm of solicitors, two partners received some money to be invested in a mortgage. The money was deposited with the firm's banker. One of the partners misappropriated the money. This fraud was not known to the other partner, but it was held that the other partner could be made liable. Okay, the other partner could be made liable. Now the next section we will discuss is section 28. It is talking about liability of holding out. Okay, so this doctrine of holding out, it is a branch of law of estoppel, according to which if a person, let's say by his or her representation, induces another to do some sort of acts which he would not have done otherwise, that the person making representation is not allowed to deny what he asserted earlier. Okay, so generally a partner who is not a partner in a firm cannot be made liable for an act of the firm, and it is quite obvious also. However, such person may, by his representation, creates an impression in the mind of the third party that he is a partner, on the basis of which the third party gives credit to the firm. The person making such representation will be held out to be a partner. Okay, so there are two essential elements here, okay, to hold a person liable on the basis of holding out. There are two essential elements, okay, that must be present. There is a first element here. The person has himself represented or knowingly permitted himself to be represented as a partner in the partnership firm. This is the first essential element. I am repeating this again. The first essential element: the person has himself represented or knowingly permitted himself to be represented as a partner in the partnership firm. And the second element here is B. Credit must have been given to the firm on the faith of such representation. I am repeating this again. Credit must have been given to the firm, to the partnership firm, on the faith of such representation. Okay. Now, let me cite one example to simplify this section 28, which is talking about holding out, liability for holding out. Okay. Let me simplify it. Now, suppose A is not a partner of a partnership firm. Okay. A is not a partner of a partnership firm. Now, let's say A intentionally created a transaction on behalf of the partnership firm, giving an impression in the mind of the third party that he is one of the partners of the partnership firm. Now, the third party here is T, suppose. Okay. The third party T also believed that A is one of the partners. Here it is to be noted that knowingly A permitted himself, in the first example, knowingly A permitted himself to be represented as a partner in the firm, in the partnership firm, and T, the third party, also believed A and has given credit to the firm on the faith of such representation which was done by A. Okay. So here, if financial loss occurs to T, the third party, because of this particular representation made by A, the other partners cannot reject T, the third party's claim by simply saying A is not a partner of the partnership firm. Here A will be treated as a partner, and entire firm will be liable for such an act, but the liability of A here will be confined to the person who has given credit. That here in this example, T, the third party, it will be confined to the person who has given credit, that is here in this example T, the third party, and to the extent of the credit that has been given to the firm on the faith of his representation, and to the extent of the credit that has been given to whom? To the partnership firm on the faith of his representation made by A. Now, there might be case, okay. Let's say, what if A himself is not aware of this representation? It may have gone too far. Like, for example, if A came in contact with T, the third party, And while, let's say, doing conversation, unintentionally created an impression in the mind of T, the third party, that A is also one of the partners of the partnership firm. Even A had no idea that this unintentional representation has gone too far. It has gone too far. The main thing to be noted here is that representation, whether intentional or unintentional, has gone to the person so given credit, that is, in this example, T, the third party. Now, to simplify it more, let's say, for example, one of A's friend or friend of A, let's say, is a partner in a partnership firm. And while talking about his friend with T, that is the third party, unknowingly A created impression in the mind of T, the third party, that he is also one of the partners of the partnership firm. Later on, what will be applicable here? Later on, the principle of estoppel will stop A from denying the previous representation, whether that representation was done intentionally or unintentionally, consciously or unconsciously. The representation which was made to the third party. Here the third party is T. Okay. So this is a very simple example. Okay, a very simple example. For the application of this rule, it is not necessary that the person representing himself or represented to be a partner does not know that the representation has reached the person so given credit. Okay. So in Oriental Bank of Commerce versus S.R. Kishore and Company 1992 decision, there were signature of the person concerned on all the essential documents and all-round participation in business. He became liable by holding out. And there is another case, Kirkut versus Chetham, okay, 1862. A butter dealer C appointed a servant Smith and started business under the name of Smith and Company. The goods were supplied to the firm by plaintiff. Court held that though no partners, servant Smith is also liable with the principal. Okay. And in another case, in Munton versus Rutherford, A published a statement in a newspaper that he and B had formed a particular partnership. As the statement was false and B did not know anything about that, it was held that B was not liable as a partner by holding out. If B had been shown the article and assented to it, the rule of estoppel would have applied. Okay. So, in order to entitle a person to bring an action under doctrine of holding out, it has to be shown that he acted on the faith of representation and gave credit to the firm at the same time. But let's say if a person, while giving credit to the firm, did not know about the representation, he can take advantage of this doctrine and make such a person liable as a partner. But if a person, while giving credit to the firm, did not know about the representation, he can take advantage of this doctrine and make such a person liable as a partner. It is not necessary that the representation must have been given directly to the person giving credit to the firm on the faith of the representation. Pullock stated in his book, Digest of the Law of Partnership, that there may be holding out without any direct communication by words or conduct between the parties. Now, the effect of doctrine of holding out is that the person who holds himself out as a partner as a partner of a firm, of a partnership firm, he becomes personally liable. But he is liable as a partner of the firm only to the person who has given credit, and to the extent the credit has been given to the firm on the faith of his representation. At the same time, the principle of holding out on retirement without giving public notice does not apply to the following cases. It does not apply to a dormant partner, B, a deceased partner, and C, an insolvent partner. Thank you.